Hi, Debbie. It's very nice to have you here today. So to our followers on LinkedIn who are watching this recording, we have here with us today from BlackOak LLC, who's a director there. So we are very happy that Debbie will speak at our webinar in September to discuss the rise of PrePack as a restructuring tool. And we will focus on 4 jurisdictions, including India, Singapore, US, and the UK. And for those of you who are not aware, Debbie actually holds the distinction of being the lead counsel for the first ever PrePack case that's been reported in Singapore. It was actually in 2018, and that was under the then prevailing Companies Act. So we would like to ask Debbie some questions regarding that landmark deal, if you will. So may I first ask, what make you think that that particular matter will be suitable for PrePack? Because, you know, PrePack was not widely used at that moment.
I think the fact that there were only 7 creditors, in the sense that the company was only trying to propose the scheme arrangement to its bank lenders. So the fact that there was a small amount of creditors, we thought that this would be a good way to test out how this PrePack mechanism could work in Singapore.
So, and I understand that in doing that case, you actually relied on some practices that are adopted in the US to basically demonstrate to the court that the procedural safeguards in the statutes have been complied with and all that. So what make you think of pointing to the US practices as your guide?
Because when the statutory amendments were introduced in 2017, it was quite clear that Singapore had taken some of these amendments from the US. So it was natural that we would try and see what New York, for instance, has done. And, because the US has been doing that for some time, it made sense to actually rely on what has been tried and tested there.
Yeah. Were you kind of a bit nervous as to how the court may react to this kind of approach?
I think as long as we made sure that the statutory requirements of Section 210 of the Companies Act were met, there shouldn't be any problem. It also helped that in the first place, the scheme arrangement provisions in Singapore, they're not very detailed. And there's actually case law which sets out the guidance and what are the requirements in terms of disclosure and all that. So insofar as you follow all that, previous decided cases, I think then you'll be generally okay with the courts.
All right. And you mentioned that, when Singapore revised its Companies Act, and it became very clear that the Singapore PrePack is primarily modeled based on the US PrePack. So is there any the obvious difference between the two systems that immediately come to mind? And what do you think, why do you think we have carved out those differences?
I think it's because primarily the US Chapter 11 process and our scheme arrangement mechanism, I think they're different to begin with. The key difference here will be that for a US Chapter 11 PrePack, the debtor will seek to solicit the consent of its creditors and approval before it actually files the Chapter 11 proceedings. But for Singapore PrePack, what happens is that the debtor company may want to apply for a moratorium first before it actually gets the creditors to vote on the scheme arrangement. So that will be the key distinction.
Yeah, about the US PrePack, because in our webinar, we'll have a US lawyer joining us and we can listen to more what he has to say about the practice in the US. And finally, my question is, you are the first one. And then once the order came into formal operation last year, there have been a number of cases reported since the beginning of 2021, actually, about the first PrePack under order, and then followed by that, the first PrePack involving a foreign debtor. So are you actually seeing a trend of PrePack gaining popularity as a restructuring tool? And, it has become a buzzword of some sort. Do you actually see that, see a trend of its popularity and all that?
The fact that it can be done relatively quicker than a conventional scheme arrangement will have some attraction to the debtor companies, especially if they are public listed company and they want to try and minimize any the period within which they undergo a scheme arrangement process. So this enables them to complete the restructuring faster. And also the simplified insolvency process for smaller companies that actually uses a PrePack mechanism, and that has actually been provided for in the IRDA. So I can see that there are more debtors that want to use a PrePack process in Singapore.
Thank you, Debbie. So if you want to learn more about Debbie, about her first case and in general about how the Singapore PrePack works, do make sure to join us on the webinar on the 9th of September, which is at 7 p.m., where Debbie will walk you through more details about her experience dealing with PrePack and how it will work under the Singapore's ERDA Act. Thank you, Debbie.
Yep, thanks, Catherine.